Meeting of the Radnor Planning Commission with the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first item on the agenda is the minutes of the March 4th, 2019 meeting. Does anybody have any comments, suggestions, corrections, additions, changes, etc. to the minutes?
I move we accept the minutes as presented.
Do I have a second?
I second.
All in favor?
Aye.
Okay, the minutes of the March 4th, 2019 meeting are approved. Next on the list for the agenda is Wawa Preliminary Land Development Plan. Before we hear from the applicant, I want to discuss with the people out front as well as with the members of the commission and also our staff certain information that we received from our council regarding the application of Wawa. And this opinion that we have received, this analysis, this legal analysis that we have received really turns on the question and involves the question of whether or not the applicant, that's Wawa, should take their application first to the zoning hearing board rather than coming directly to the planning commission. And that's based upon an analysis of the C2 zoning district, which is where the Wawa store and gas station would be situated. And that analysis indicates that there are three commercial zoning districts that would be that we have to take into consideration in analyzing the appropriateness of this particular application, C1, C2, and C3. The application, the applicant seeks to put two lots together and build the Wawa, as we all know, in a C2 classification area. And there has been a fair amount of contention here, and it was decided to look into what the zoning really says and what could and how it should be approached. I don't think there's any question but that the Wawa store without the gasoline pumps is a convenience store, and it is a retail operation. Retail operations are permitted in the C2 district. But it's just not as simple as all of that. The zoning ordinance requires that all uses in the C2 district be located completely within the enclosed structure. Now, we all can apply our common sense and know that gasoline pumps are not enclosed within the structure. The zoning ordinance requires that no goods shall be displayed or offered for sale beyond the front lines of the building. Now, that would be a non-conforming use. And as all of us have probably seen, the Sunoco station, like most gas stations, have pumps out front, and they're outside the line of the building. They're not enclosed, and they're not within that line of the building. So it's a non-conforming use. It also turns out that the Sunoco station sitting on that particular lot has been recognized since at least 1954, I believe, when it was an Esso station originally, as a non-conforming use. Much can be said of the lot next door, which is the one with the the car wash, and it's a BP station. The ordinance does not address convenience stores as convenience stores, with or without gasoline sales. But as I just said, I think everybody can agree that a Wawa without the gas pumps is a retail use. So much of the debate on this subject turns into a discussion of nonconformities. And there are nonconformities that are use nonconformities and dimensional nonconformities. Article 20, 280-101, forms part of the basis of the legal opinion that we received from our counsel. And it says in so many words, the Pennsylvania law and our statute distinguishes between nonconforming uses and nonconforming structures. Now, I must admit that when you read through a lot of this, it's enough to make your eyes glaze over, but these are really important distinctions and ones that need to be addressed. So rather than struggling through this, I'm going to ask our counsel, Ms. Eberly, to pick it up at this point and describe to us the basis and the distinctions between these types of nonconformities and how and why a nonconformity under the circumstances as proposed here by this applicant would require, in our opinion, and it is the opinion of counsel, that they would have to apply to the zoning hearing board and at a public hearing explain and ask for relief from the zoning hearing board, whether it's in the form of a variance or in the form of a special exception. Ms. Eberly?
Thank you, and I don't want to make this overly complex, but the proposed use of gas pumps on the property is probably, and I say probably because there are factual issues that would need to be fleshed out in front of the zoning hearing board, is probably a use accessory to the convenience store. If it's identified as a nonconforming use, your zoning ordinance requires that a change in occupancy of a nonconforming use is the same as a change in a nonconforming use and requires a special exception from the zoning hearing board. If the nonconformity associated and identified by the zoning officer is a structural nonconformity, then when all the buildings on the property are raised and these structures or the structure to house the gasoline pumps or the fueling island dispensers are located differently in a different structure, the original nonconforming structure is abandoned and the applicant must come into compliance with the zoning ordinance. So if the nonconformity is a structural nonconformity, a variance is required. If the nonconformity is a use nonconformity, then a special exception is required. There's two different sub-issues. One, there's a provision in your zoning ordinance that doesn't allow the sale of goods beyond the front building line, and I think there'd be a variance necessary for that. And there's also the rear property line issue that was identified in the legal letter submitted by Mr. Greenfield on behalf of the residents. There's a lot of paths and a lot of different facets to this particular project, but every road leads to the zoning hearing board.
Thank you, Ms. Eberly. Thank you for your opinion and your work on this matter on behalf of the Planning Commission. Ms. Nick, would you like to say anything?
Yes. I was made aware of this at 3 o'clock on Friday afternoon, just to give the board an idea on how quickly we had to come to consider this. Just a little bit of history here. Back in April of 2018, a year ago now, I sent a letter to the zoning officer requesting an interpretation of the use of this site. With that interpretation, I included a site plan, which includes basically the plan that you see before you today. On April 27th of last year, again, approximately a year ago, we received a letter from the zoning officer saying that the use was permitted. Based on that letter, we started developing land development plans. We submitted a preliminary plan back in August 31st, 2018. We granted various extensions to this board. We met with the neighbors probably 4 times, separately with the Board of Commissioners. We met with this board back, I believe, in November of last year. We've also received 2 sets of review letters from both the Township consultant engineer as well as the Township traffic engineer. In none of those letters was it ever mentioned that this use is anything but a permitted use. Based on the letter that we received from the zoning officer, the Caracellians, not Wawa, the Caracellians, my clients, who have been in this community for probably 45 years, who I've represented for 30 years, expended probably about $150,000 in engineering fees, which brings us here tonight. Now, on Friday, I get a phone call saying, Nick, want to let you know, we're going to say that this use is not permitted. After we received a letter from the zoning officer stating that the use is a permitted use. Let's look at that now. One, everyone agrees the retail use is permitted, that the store itself is permitted. The question was on the gas pumps. We have the old plan, or the current site, indicates 21 fuel points, or 21 gas pumps. That's being reduced to 12. 12 dispensers being reduced to 6. Based on that, the zoning officer issued his opinion, which you should have in front of you, saying this is not an expansion of a non-conforming use. This use is actually decreasing the non-conformity, therefore is permitted. Next, it was cited earlier this evening that the township ordinance, and it's very true, states that a change of occupancy shall be deemed to be a change of use. I think everyone on this board knows when you get a variance, when you have a nonconformity, that runs with the land. It is totally illegal to come in and say that because you sold a property or you're changing occupancy, that now you have to go to zoning and get approval of that nonconformity, that existing nonconformity, which in this case has probably existed for 70 years. So that is clearly outside of the law. It's contrary to the MPC. It's contrary to the state constitution, which protects nonconformities. So I guess the conclusion is this board can determine, or the Board of Commissioners have final say, can determine that we have to proceed to the zoning hearing board. Based on that, we're proceeding with this plan, unfortunately, which we know several of the neighbors preferred some of the alternatives which we showed to them. Most of the neighbors actually opposed the whole development, didn't agree to any of the alternatives that we showed. We will be proceeding with this plan, which we know most of the neighbors are not in favor of, which we're willing to flip the buildings or move the buildings to comply. We just needed some guidance from the Board of Commissioners, which they refused to give us. So that brings us here tonight. If the BOC is going to deny this plan based on this use, we're very comfortable proceeding to common pleas court over it. So, I mean, I can go through the review letters, but it may be a waste of time. I don't know if we want to sit here while I go through the review letters.
If you want to go through the review letter, that's your option.
No, I
But
don't
if
think
you
there's any need to go through.
If you don't want to, it's okay. I'm offering you that option to go through the review letter if you care to.
Hey, Nick.
Excuse me for a second, please. Before you interrupt. So we're agreed you're not, or you do want to go through the
No, well,
review
I guess
letter?
the question is if this board's going to determine a denial based on the use, we're wasting our time to go through the review letters. I don't want to keep everyone here for another 2 hours. So if that's the determination of the board, they're going to deny the plan based on the opinion of council, that's fine, But again, if the board wants to hear the review letters, we can go through it. But probably, it's going to take an hour, 2 hours, and you're going to hear comments from the neighbors, and it could waste all our time.
I'm asking you if you want to do it. It's your call.
Well, I guess the question is, I will go through the review. John, I'm sorry. I don't want to waste everyone's time here. I understand. I'm not going to argue that at a later point you need to give me an opportunity to go through review letters. I'm not going to make that argument. But I'm just saying I don't want to waste everyone's time for 2 hours, if the board's mind's made up.
Nick, can I talk now? Sure. Why can't you give an extension till next month so that we can hash this out without going through all this aggravation between what your opinion is, what our solicitor opinion is, and what our zoning officer is? Because we obviously have 3 sets of opinions. So I think we need to, in my estimation, I think we really need to figure out which one is correct and deal with the correct opinions. And I agree with you. Going through the review letters now and doing that for 2 hours is really just a waste of time because we're kind of in the same bind you are. I would suggest that you do maybe postpone it till next month, ask for an extension, and deal from that.
I mean, yeah, okay. I don't know. Who's going to make, is this board going to at least initially determine, or?
You know, this is just like you heard about it. That's the same time we heard about it. So, you know, this is sprung on us as well as sprung on you.
And I'd like an opportunity probably to respond, you know. to the letter
I
until
agree,
the
but
matter is
I
stated.
think everyone should, but I think you should probably get it done instead of, you know, in a amphitheater kind of a situation, just to find out who's right and who's wrong. That's my opinion.
I mean, I really have no problem with that, but again, I don't know if you're going to take the opinion of her solicitor, I think her mind's made up, you know, so, but.
You want an extension till
Sure.
next
I mean,
month?
I'll ask for an extension.
Okay.
And hope to address it and send a letter to the board, explain our point of view. You have the solicitor's comments, you have Mr. Greenfield's letter, and perhaps I can also do a memo to the board to explain what our position is on it.
And that's my opinion, but I'm
I mean,
one
that's,
of
you know,
a group.
if the board's going to keep an open mind, if you think your minds are made up, again, we may as well, instead of wasting everyone's time, we should just proceed forward.
Sorry, at this juncture, then, we have that one voice down there. I can ask for a motion, or we can have more board comment. I think what I'll do is I'll ask for a motion. Do I have a motion?
So moved. You have to ask for an extension before I make a motion, I think.
If the motion carries that I think is going to be made, we would ask for an extension and give the board an additional 1 month, 30 days.
Right now, I think the extension expires on May 13th.
Yeah, so go to
So are you, but,
June 13th.
but the May 13th date is tied into a Board of Commissioners
Correct.
meeting, so maybe we can just check the Board of Commissioners meeting closest to that date, so we again tie it into a Board of Commissioners meeting?
June 10th is the second Monday.
All right. I like sticking with June 13th, which gives John time to communicate.
Sure, that's fine.
Thanks.
Okay. So the extension would be until June 13th?
Correct.
Okay.
And I think Mr. Norsini and Mr. Kachansky over here are going to want to have that in writing.
Yes, Mr. Cornelia will be sending me a letter, like he would normally do on an extension.
Yeah, I made it verbally, and I will also send a letter if the motion's approved.
Okay. So, any further comments by any members of the board?
Just to clarify, the motion's going to be to continue for 1 month?
I'm waiting to hear the motion.
Oh,
I move that we continue probably to the July meeting if they're going to meet the, no?
No, yeah.
What,
June.
May.
May? May.
Yeah.
I move we reconsider this table it till the May meeting.
Second?
second.
Vote? Okay.
Thank you. I'll send Mr. Norsini the extension letter.
Let the record show that the motion was approved, I believe unanimously. Next on the agenda is 360 Conestoga Road. I don't think we're going to worry about that. No, I don't want to, I mean, maybe invite, I just want to worry the Blue Stein. But what are we going to do? Listen to an hour of them moaning about whatever? Right, because it's, we just, I think tabling it is, I think so. I think so, okay. We just kicked the can down the road for no good reason.
So it's basically just going to be, who's going to make the decision? How are you?
John, can you take one quick public comment? One quick one.
Okay, there's one. So just for the record, we're going back onto the Wawa thing for just a moment while Mrs. Stern gives us a public comment.
Sure. Thank you, Mr. Lord. I appreciate the consideration. I just wanted to ask if the public could expect to see whatever the letter this is that Mr. Greenfield sent and that apparently your solicitor sent. Will they be posted on the website on the Wawa page? Where can the public see these letters? Because, you know, most of us haven't seen these letters.
Well, the Greenfield letter is available to anybody who wants to see it. The memo,
Is it on the website?
I don't know.
Okay.
Not yet, maybe.
So that
but
was
it
my
will be.
question.
The Greenfield letter is in tonight's packet, which is on the website.
Thank you. And then
Okay.
the solicitor's letter?
Well, I'll consult with our solicitor before we make a decision on that
Perfect.
point.
Thank you so much. I appreciate the consideration. Good night, everyone.
All right, now it's 360 Conestoga Road.
Good evening. My name's Andy Eberwein. I'm with Edward B. Walsh and Associates. We're civil engineers in Exton. We prepared a minor subdivision plan for 360 Conestoga Road. My client, Mrs. Rauscher, is in the audience if you guys have any questions for her tonight. It's a final minor subdivision. So Mrs. Rauscher owns along with her husband, the property at 360 Conestoga Road. She wants to create a lot off of that property of 23,340 square feet, maintain 1.14 acre parcel with the existing house, pool, driveway, and other improvements that are on the property. So under your code, it is a minor subdivision. We have received comments from Gannett, Fleming, and Gilmore, and we can go through them. I think we are pretty much in concurrence with what they're asking us. There are a couple waivers that we would like you to consider for this plan, but and I would like to go through them if that's okay with you, and then any questions you may have. Does that suit you, Mr. Chairman?
Okay. Go ahead. You're referring to the March 20th, 2019
Yes.
Gannett Fleming report from Stephen Norsini, PE, to Roger Phillips, PE? Is that correct?
To Mr. Norsini from Roger, yes.
Yes.
Yes. The Radnor Township subdivision land development ordinance, actually your application package requires a title report to be submitted with all subdivision plans. This is a minor subdivision plan, and Mrs. Rauscher has owned this property for 25 years. She does not have a title report. We didn't do her title report. We got her deeds obtained. I'm sorry.
For the staff, is that an issue? Is that something that's waivable?
Roger just asked that I field this. The requirement to have a title report is as much for the protection of the applicant and subsequent property owners as it is for the township. What we're looking for most on the title report, other than knowing that the person owns the property, which is not an issue here, is whether or not there's any restrictions or easements on the property which would interfere with the subdivision that's being proposed. The actual cost of obtaining a title report is relatively inexpensive, and the time necessary to get a title report is also inexpensive. But if we approve a subdivision and they record it and go to settlement to try and sell one of the lots, and an issue first appears on the title report at that time, that's a world of pain for both the applicant and the prospective property owner.
You're going to have to get a title report.
We, I kind of gathered that from that as well. Thank you.
So what's number two
What I would,
here?
well, if I can stay on number one for a moment, I would ask that if you consider moving us forward, that you do that contingent upon us obtaining a title report and providing the township with a clean title for this property.
Well, on the record, you're going to say that you're going to
We will.
comply with number
Absolutely.
one under subdivision land development on the memo that we just referenced.
Absolutely.
Correct? Okay. Let's move on to page 2, number 2.
We'll comply with comment 2. Roger has asked us to provide the meets and bounds on the piece of property that was accepted out of the deed many, many years ago, not part of Mrs. Rauscher's property. It's located, if you look at the screen, to the west of where her driveway is. There was an exception made a long time ago. It's listed in the deed. Just for the matter of, I guess, considering clear title, they want that on there. We'll provide it. We have the information. It's just, it wasn't part of the property, so we didn't put it on. We will put it on.
Okay, how about item number 3?
We are asking for a waiver of that because it is a minor subdivision. If we, and you guys don't want to support that, that's fine. We can provide an aerial photo of the area within 500 feet of this and create a plan that shows the area with this property on it. I mean, we can certainly do that if it's your pleasure.
There's no improvements proposed with this at this point, so I would not object to that waiver at this point. When they come back later to construct something on that property, there'll be a lot more scrutiny under the grading permit process for surrounding utilities, et cetera.
We'll grant the waiver on item 3.
Thank you. And item 4 is labeling the cartway, which we will do. It should have been on here, and that's an error on my
Okay, so
fault.
that's a will comply on labeling the cartway on item 4.
Yes. We will provide new deeds, obviously, when...
You're under general now?
Yes, I am. I'm sorry, sir.
Okay.
So under comment 1, under general, Roger's office is asking for new deeds. We have to create new deeds. We will do that when it gets recorded. And there are steep slopes along the frontage. They're noted on the drawing. We're not asking for anything on that at this time. I believe we're allowed to put a driveway access through that, and we'd have to deal with those issues if we come in with a grading permit or building permit application for a house on this property.
Roger, is that correct? I mean, all that will have to be dealt
Yes.
with, and they have to get some permission from PennDOT, am I correct, to open a driveway?
They'll need approval from PennDOT also to construct the driveway, correct.
All right.
The Gilmore Associates letter is basically pretty much the same comments, and we will comply with them as well.
Let's take a quick look at those to make
Okay.
sure that we didn't miss anything.
On the first page is this background documents reviewed. Comment 3 is talking about the major collector and labeling the right-of-ways and the cartways.
Is that a will comply?
Yes. Comment 2, stating that we need to have a PennDOT permit. We know that. We will comply with that when the time comes for that to be applied for. Comment 3, they're asking for us to show the site distances for the existing driveway. We'll show the site distances for the existing driveway. It is an existing driveway, but we will show the site distances for that. And comment 4, I just view as comments. I don't really know how to,
Well, that's really entirely up to the Board of Commissioners.
yes.
I'm sorry. Is there any board comment, or I should say, questions first for the applicant or board comment regarding the application?
You've seen the letter that we got, the neighbor letter?
You know, we do have a letter dated April 1st, or an email dated April 1st that was forwarded to us by Steve Norsini from William Phillip, who lives at 362 Conestoga Road. He raises several issues regarding the subdivision. However, I believe that, and I'll ask staff to chime in on this, but I believe that these are the types of issues that would be raised when, if and when there's going to be a building placed on this property.
You're correct, Mr. Chairman. So right now, it's just the lot line change. When they come in, if they come in to build something, that's when stormwater management would be reviewed. So right now, there's no changes to the topography. The land stays as it is. It's just a subdivision, lines on the paper. But should that lot sell and somebody want to construct, that's when stormwater management would be addressed. But I am responsible to make sure that this commission and the consultants and everybody sees that email from one of our residents to express his concern. I told him it would be forwarded on to you, and I would let him know tomorrow, he's in California, that right now nothing occurs for stormwater, but it will be addressed at one point.
And at that point, he can renew his concerns. Would this come back to us at that point?
Not for the grading permit, no, that's handled internally, but we now are aware of his concern and we'll address it with Mr. Eberwein at that time.
Okay, thank you.
I do have one more question. Okay, so sometimes, when we get letters like this, they have concerns about just the maintenance of the property in general. He's expressed some concerns about, like, the tree on the yard and some other things like that. What kind of responsibility do we have right now to address the maintenance of the property for the safety of the neighbor in this letter, or does that also get pushed off?
So based on that, we can have the township arborist, it all depends. If a tree's within the Conestoga Road right-of-way and our arborist deems that hazardous, we would contact the Pennsylvania Department of Transportation. If there's a tree deemed hazardous on the property, we would notify the homeowner, but that's more of a civil issue that the township does not get involved with. We're basically involved with trees within the right-of-way, who's ever right-of-way.
Any public comment? Come on to Mike and give us your name and address, please.
Hi, I'm Richard Butkosk. I live at 325 South Wayne Avenue. A couple questions on the site plan. There seem to be some either math errors or number errors. If I'm looking at the width of the lots, Lot 1 is listed as coming out as 277 feet and some change. It actually appears as if it should be about 227 feet, not 277, scaling it off. Lot 2 is shown as a width of 172, and in reality it's about 122.
But it says 122 on,
I'm sorry?
it says 122 on lot 2.
I'm looking at a 172.
It's in the upper left-hand, upper right-hand corner under the cross hatching, or the hatching.
That needs to be changed to that.
Okay, and the 277?
It's 277 for the,
In reality,
oh, that's good.
it scales out at 227.
If it is 227, we'll change it to 227. I will check that. I mean,
the question
surveyors
is-
would have counted and would have shown it. If it's incorrect,
The bottom shows
Yeah, the
227.
bottom shows 227 where the stockade
They're
fence is.
dimensioning it to two different points.
In the back,
it could be a bad label.
Where are you seeing 227?
If I can add to this, this was what generated one of the comments in my letter, that all of these dimensions get cleaned up for both the existing and the proposed. There were some issues with the existing deeds that things didn't add up, and that's why I'm asking that all be cleaned up, and Mr. Eberwein has agreed to do that.
Well, trust me, I'm a registered architect. I can understand some discrepancies on a deed. Discrepancies when somebody prepares the drawing is a different animal. That's-
Exactly, sir, which is why I asked that it be revised.
So I guess I'm looking at this. I got lot widths that are in error on the summary.
Can you please talk into the mic?
There are lot errors on the summary. And I guess the question is, it appears as if the front lot line does not follow the contour of Conestoga Road. Is that correct?
That is correct. It follows the right-of-way, the PennDOT right-of-way along Conestoga Road. PennDOT changed, sorry, PennDOT, you don't mind if I talk here, do you? PennDOT altered and took right-of-way along the frontage of this property when they did some improvements out along Conestoga Road, and the right-of-way that you see is in fact from PennDOT. We are proposing an ultimate right-of-way, which will be 40 foot from the center line, which would be that line there, which would make it parallel with Conestoga Road.
Okay, not having seen the deed, I can't speak to that. I'm looking at, I see at least 3 number errors down on the bottom here that, in order to make this drawing believable, need to be corrected. I don't know how it affects square footage of the lots, which numbers were taken into account and which ones
Well,
weren't.
I think it's been made fairly clear that our staff has already made these observations. It's noted in the Gannett Fleming, March 20th, 2019 report from Mr. Norsini to Mr. Phillips, or from Mr. Phillips to Mr. Norsini, and it's right on, under General, on the second page, and it says there are minor discrepancies with the existing deeds and plans that will be addressed at the time of the new deeds being recorded. So that it's going to pass muster with our staff before anything gets recorded.
Shouldn't that be corrected before it gets approved?
It's going to get corrected before it gets recorded by our staff.
I mean, I'm
Am
looking
I
at a
correct?
30%
It will be
difference.
corrected before the plan moves forward to the commissioners.
Okay, I'm looking at a 30% difference, discrepancy on.
It'll be
the-
corrected before the plan moves forward to the commissioners.
Just saying.
That's the procedure.
Thank you. Any other public comment on this particular application? Oh, boy. Now,
Hi, Baron Gemmer. I live at 335 South Wayne Avenue, two houses from Rick. I won't go over the number discrepancies. We'll let those pan out, and then we'll take a look at those before they get to the Board of Commissioners. But obviously, they are important before they get recorded, because we have to make sure they pass zoning even before the Board of Commissioners can approve them. First, just an administrative clarification. On the March 20th review letter from Roger, and maybe Roger's is a better one for you, it says date accepted April 1st and 90-day review June 30th. Is that doesn't seem right, but I just wanted to.
That's the official acceptance date under the rules of the MPC.
So today you're saying?
That is correct.
Okay, just wanted to make sure on that. Thank you. Per what the comment was with the numbers, part of why it's important with the numbers, I think they're saying it's an 82 foot front yard, and obviously once you actually do the true 40-foot right away from the center of the road, that's no longer 82. So part of the reason, like Rick was up here, is some of these are zoning setbacks we need to make sure are correct, and unfortunately it sounds like you guys might be passing it along subject to change, and then the Board of Commissioners may have to deal with it, but that's some of the important part. But the right-of-way here, I guess I'm confused, because is the applicant claiming that the parties over here on the opposite side of Conestoga own all the way to here? Because just typically the easements and the right-of-ways are still owned by the property owner. That's why we're questioning this, just because they've taken more. Usually everybody owns the center, whether there's subsequent easements that go farther along or right-of-ways like that. So I would request that get clarified, because usually we don't have roads that are not owned by either of the abutting property owners.
Roger, any comment?
No, again, that falls into all of what we've been talking about already, and that'll be something that'll be identified also in the title report.
Okay. And then the last comment would be, because now when this lot is developed, and this may be something the applicant may want to consider, when this is built upon, because of the nature of the lot, and this is before the zoning hearing board actually this Thursday for a different lot, because it has steep slopes, one of the provisions of the steep slope ordinance 28112 says that any lot that didn't exist at the time of the implementation of the ordinance, which this lot wouldn't because it's being created now, it has slopes greater than 14%, has to go before this board and the Board of Commissioners and meet all the salary requirements. So I just say that for the applicant's purpose, that if they plan on building, they may want to try and wrap this all into one and do it now, as opposed to having to come back for essentially a second saldo application when that's built. And that's 280-112F. Where development is defined as any improvement to the property.
Thank you very much. Any other public comment on this application? Okay, any board comment, questions? Can I have a motion, please?
Can I make one comment? I don't think it's unreasonable to ask for a plan that's accurate, or a plan that's presented to us to review and approve, that it be accurate. And I would not, and I'm not sure why it isn't rejected at the staff level and the engineer is asked to make those changes and resubmit.
You know, this falls within the category, I guess, I hate to use the word I guess, but the discretion of our staff, our professional staff on things like this. I know what you do for a living, Steve. But
Mr. Chairman, if I could just chime in.
Sure.
So as staff, we do not have the authority to reject a plan. So once it is submitted, it is reviewed, and it's reviewed within the subdivision land development ordinance and zoning ordinance. Those review comments are provided to this commission. We do not have the ability to administratively reject the plan, which leaves this commission with options: recommend approval, recommend denial, or ask them, table it, and ask them to bring it back with changes. But we don't have that option.
are there any time constrictions on this? Are we running up against a time constraint? Based on what I just learned, I would like a motion regarding tabling.
I'd like to make a motion that we table it for 30 days to give the applicant a chance to fix all the things that he's already identified that he will comply.
Second? Second? All in favor?
Aye.
So let the record show that the Planning Commission tabled the application for 360 Conestoga Road to come up, I believe it would come up in May.
I need to say something. I think that we did the right thing here, I guess, tonight on this specific subject, but if we continually to do that, I think that we won't get a lot accomplished, because now we have two things that we had tonight that are coming back next month, plus whatever else happens in the course of the next 30 days. I think that our staff is professional enough and knowledgeable enough in their duties that when they catch these things and when the final product comes through, minor things like this. Now, if it's a major difference, I think we're right. But on minor things like dimensions, that I think they can correct it, and when the final approval comes, it'll be done right.
I think you have heard the expression, the nose of the camel in the tent. And pretty soon the camel's inside the tent. And I really do think that occasionally we've got to take a look at this. And I think, to Steve's point, I think he's correct. If these dimensions are off as much as the two individuals who came up and testified are correct, and I believe they are, and we find that the staff doesn't have the ability to reject, it really falls to us to make a decision as to whether or not these differences are so de minimis that they can be overlooked. And that requires a bit of a professional decision that I don't know that we all have the basis to make, when all we're asking people to do, and we should be uniform as much as possible, all we're asking them to do is present professional, accurate plans. And these things are sealed by a professional engineer, and consequently they should be right. And if these are not right, then we should send them back. And when they come back, they'll have passed through the staff will take a look at them. I don't believe it's going to be particularly time consuming. and they will then tell us, all right, they got these things fixed, we're done, we'll just move right on, it won't take much time at all.
Mr. Lord, if I could add one thing to that, the items that we note in our review letters, you use the term overlooked. It's not something that we overlook. We require that to be done, and if you would pass something with that attachment to it, we would make sure that everything was adequately addressed that's in that letter, and if it's not, it doesn't move forward. It doesn't move forward till we are satisfied that they've complied with that. We don't overlook things that are noted in our report.
Oh, I assume that's the case, but I guess it becomes a question of degree. I mean, to what extent should we place back on you the obligation to make sure that everything's right when it isn't right when it comes in the first time?
Well, I believe that's why they hire us. So.
I think it's exactly, he said exactly what I'm saying, is that, you know, that's their job, that's what we pay them to do, to find the mistakes, and we, all the time, most of the time that I've known, both on this board and in zoning, pass things with stipulations that they must be correct before it's done. And that's all I'm saying, is that we can pass things like this and say, hey, look, we're going to pass it and move it on, but they need to be corrected to the standards that our staff sets and the ordinance sets. That's all I'm saying.
We do this all the time with will comply. Do you comply to all the things in here? And then, so we have to, I mean, it's fine to ask for certain corrections when you're concerned about if it's actually going to work, but I think we have to also understand that you're not, very rarely does a plan come through here without some sort of letter. So are we going to reject them all, or?
No, I don't think we're going, well, even remotely suggesting something like that. It said that a plan like this gets translated and used out in the field. And that's a little bit different than, you know, something written down here that you've got to take these following steps, and you'll say, we'll comply, we will do that. I mean, if you want to unwind it, I'm fine with it. I think we have to have another motion to.
No, we're fine. I'm just saying in the future, I think it's right if it's something major, and this is a good thing to do tonight, because maybe the next person will take an extra second to look. And that's the reason why I voted for it, okay? But I think overall, what our staff is supposed to do is exactly what it did in this. It pointed that these situations and problems are there, and you know, they will, and then it's up to us to say, yes, you need to correct this, and that's all I'm saying.
But now that we've had this clarification, what is there involved with us to go back and say, okay, fine, we'll approve it subject to?
Let's move on, John.
You sure?
I would request that you consider that. I mean, we are a professional organization. There are some labeling errors on here and discrepancies that will get straightened out, and Roger will make sure they are. I have licensed surveyors, licensed engineers on my staff who work for my company. And, you know, we cannot, you know, or would not try to put forth these items. There's a couple labeling discrepancies. The lots are calced, the right-of-ways are calced. We did a field survey, you know, of the property, utilizing the existing deeds. I don't believe that, you know, these little errors are going to change anything on the drawing except for a couple labels. Your decisions are your decisions, but I really believe that. I mean, we are a professional organization.
Let me get some sort
of
a sense from the board as to whether or not we want to unwind what we just did and allow our staff to make sure that the corrections, the plan is corrected as necessary.
I kind of like what we just.
My point was
did.
that the professionals that come before us and make presentations should be presenting as accurate as possible drawings. They shouldn't be so loose as to say, I'll correct that later, and we rely on staff. The staff is probably very busy the way it is, and for us to expect them to pick up errors that are really part of the engineer's job, I don't think that's fair to the staff, but it's also not fair to us as a board to be reviewing drawings that aren't accurate. Mistakes happen, I understand that, and I know it's not intentional,
I
but.
have trouble with the term inaccurate. What's not accurate is a couple labels.
Excuse me.
But that could be. I wasn't suggesting that you were not a good engineer. That's not the point. The point is we just want the drawings that come before us should be as accurate as possible.
I agree.
I actually agree with you. It is a matter of degree. I wouldn't want to do this over and over. I just think that this, you know, I'm looking at it, and two sides of the same drawing have different numbers, and it bothers me a little bit, that's all. And it's a 30-day wait. You already agreed to do all this, and it sends a minor signal that, what we get should be pretty good.
And I would chime in that a near neighbor sent us a letter where he has concerns about the lot lines. And I think under those circumstances, let's get this right before we approve it, because just for the sake of the neighbor who can't be here.
So is the sense of the board to leave our motion the way it is? Okay, fine.
Thank you.
So the next item on the agenda is Jaguar Land Rover.
Evening. I don't think this one be as contentious.
Didn't we get rid of you last month on this?
Yeah, you looked at this last month, so I'm going to quickly go over it. Remember, you sent us back to the zoning hearing board.
Right.
And we did go to the zoning hearing board. It was approved for the size of the parking spaces, number of parking spaces, and all the parking issues. So, again, you may recall, we talked about last month how this project that maybe Charlie and I may be the only ones that remember back to 2004, but this at one point was before the zoning hearing board. The township came to us and said, let's do a different type of development here. We would like to, at that time, back in 2004, it was a car dealership, had all the parking out here. The car dealership was in the back here. Mr. Smythe took over the property. We came in to look to put an addition on the car dealership building. And the township said, let's do something different. And they said, how about moving the building up front, which we did. How about if we rezone in the rear here to condominiums, which were done. That's the Pembroke North condominiums. And then we subdivide the lot so that the car dealership is on this lot, condominiums back here. Mr. Smythe still owns the car dealership, now a Jaguar Range Rover, I think, as you're all aware. There's a couple things the township wanted us to do, which was done. That one is put the building up. Two, move all the parking either on the side or behind the building, and also as is preferred along Lancaster Avenue, although it's sometimes just not able to be done. They wanted a winding sidewalk pulled off the street so that it's more pedestrian friendly as far as walking on the street. What brings us here this evening and to this land development process was that Jaguar International or Jaguar National required renovations to the building, which included an addition to the building. As a result, we had to move parking around to accommodate the code. Back in 2004, I think we required 62 spaces, Karen. We still have 62 spaces. The existing plan does indicate 67, although, as we mentioned to the zoning board and here last month, I believe, is that some of those 67 spaces were not conforming as to size. We've since removed them. What we've done, and the zoning board has agreed to permit, is that most of this parking here is really for display purposes. As you're well aware, there's not a whole lot of customer access coming in for purchasing cars anymore. They do come in. Most of the time, the busy day is Saturday when the repair situation is not going on. So cars do come in the morning for repair. They drop them off. And then if any customers come in to purchase, obviously it's later in the day when the repair business, the cars are already inside being repaired. Mike can address that further if you really need him to do it. So as I mentioned, there is some stacking of parking. The parking over here, these 6 spaces actually are the same as were approved by the land development plan back in 2004. And unless there's any other questions, I'll go through the review letters.
I'm sorry, any questions? Okay. So let's go through the March 20th, 2019 Gannett Fleming review letter.
Okay, Karen, if I need you, why don't you come up? Karen McManuel is the project engineer on the project. Going through the review letters, Roger's first couple statements, I think, were just basically statements. We are asking for certain waivers on this. One is that this be considered a preliminary final plan instead of a preliminary plan. Basically, what we're doing here is we're not changing much. We're adding about 3,000 square feet of floor area, of building size to the building, all in the rear. So none of this would really be
Can I
seen
ask
in
a
front.
question? What's different tonight than we did last month?
We got the zoning approval.
So why are we doing this over again then? Is
Oh,
there something different?
you
Is there
tabled.
something different here, Steve, that I'm missing?
It was tabled,
was
they had to
tabled.
come back. So,
We
It
didn't
was
go through the
tabled by
review
us?
letter.
I thought we passed it. I thought we recommended that it move on, that I said you get your pound of flesh from them. I thought that was the verbiage I used, and it moved
We're
on.
happy.
My notes reflect that you made a motion to recommend approval, and it was unanimously approved.
Oh, that's what I thought.
well, they're back, I guess because they, it's because of the zoning, so they're back. So
We got zoning approval, so we're good. Thank you. Sounds good to me. I'll happily leave.
I'm looking at the minutes, and it says recommended to approve, to accept and approve the zoning hearing application, approved date the 0, so we accepted the application, but I don't believe we went through the review letters.
I stand corrected.
it's not the land development application. So anybody that goes before ZHB has to come before Planning Commission for the ZHB application, which is a separate item than the land development application.
I'm back. You're right. Yeah, I recall now. That it was to.
Thank you, Mr.
approve-
Cornelia.
Yes. It was to recommend that we have no problem with the zoning application portion of it. It was not to approve the plan itself.
Correct?
Yep.
Okay. All right.
sorry.
So we're number 1, you want a waiver for,
Being considered a preliminary final plan instead of a preliminary plan, which basically means that this will just go through one-time process. It won't come back with final plan. And reason for that is really just an addition to the rear of the building, a 3,000 square foot addition to the rear of the building. And even though it smacks of being a preliminary final plan, I believe the analysis now is that we have to ask for a waiver if that's what we really want.
let's just go through these. I know there's some will complies in here, a bunch of
Yeah,
those,
yeah,
right?
there are,
Okay,
yeah.
so we'll just take this first one right now. What's the sense of the board, of the commission on giving a waiver on item number 1?
That's fine.
All right, so that's a waiver. How about number 2?
Number 2 is, again, it's another feature that's in the zoning, that's in the land development ordinance that says basically you have to show all easements, all storm drains, everything within 500 feet. What is commonly done now, and I believe was done here, is we do an aerial view of that so that you don't have to go out and survey everything within 500 feet. Again, I think it's a pretty common waiver.
Right, is everybody, I think it is too. Is everybody okay with that?
Yes.
Item number 2? All right, so that's a waiver, granted. Number-
And 3 was the one on
Parking areas.
parking area. Karen, do you have it there in front of you? Yeah, the trees. The trees. Do you want to, and this is actually 3 and 8 are basically the same thing. 3 here, and then 8 under subdivision and land development is really the same issue. So, I'll let Karen address that.
55-29B on page.
Yes,
page-
comment number 8B1.
Got it. Thank you.
So all this is existing parking. We're not proposing any new parking on the site. So we didn't feel that it was required to add any new trees for the parking because it is existing condition and we're not really changing it.
Again, how does everybody on the board feel about that? Waiver, haven't put trees in? Yeah, Matt, how you feel?
I think that's fine.
Okay.
Mr. Shade.
Yeah, Mr. Tree. Okay down here? All right, so there's a waiver granted on item number 3.
Mr. Chairman, before you continue on that,
Yeah.
before we get off of that, just from my personal standpoint, I understand parking is a huge issue here, and they don't feel they need to plant trees, but I would request that they, whatever the appropriate quantity of trees is, they pay the fee in lieu of to the Township Shade Tree Fund. We have a lot of projects that are out there, highly impervious area in Wayne, and I understand it would not be advantageous to the site to lose the trees to those parking areas, but if they would wish to pay the fee in lieu of, it goes directly to the Shade Tree Fund for future tree planting in the township.
That works for me.
How do you feel about that?
We're good.
All right. It's a great idea, thanks.
That's just a note.
But, excuse me, are you taking out that clump of trees that's kind of in the middle of the parking lot? I don't have I see one now on the site in the aerial. There's some bushes or trees or,
There's some shrubs right here in
Is-
an island.
Okay.
There's no trees. Yes, those shrubs are going to go away.
and that island's going away also?
That island's going away because the building addition is coming out the back, so this parking lot, these parkings are getting pushed out here, and that island goes away.
Okay.
Going down to zoning, number 1. Going down to zoning, number 1, that's noted. We agree that's what's occurring here. And I think all these zoning issues are basically kind of noted. We agree, yeah, they're noted, that Roger raised these issues. And I think it's mainly informational with the board, so the board's aware of what is happening.
When you went before the zoning hearing board, weren't these taken care of?
The impervious is a nonconformity that we didn't have to take care of. The parking spaces were taken care of, which is number 2. Number 3, again, I think he's noting that we're not required to have it because we have 3,500 as opposed to 5,000, which is required in the code. And where we have 4,700, where 5,000 is required in the code. And then, of course, number 4, we have to comply with whatever the signage ordinance is when we do signs. There's nothing on here regarding signs right now. That would have to go to design review and be reviewed by the zoning officer to determine compliance with the code.
That's correct. The only item that they had to take care of was number 2.
Very good. Subdivision and land development?
Right. 1 will comply, the soil map, right, we'll comply with that. The boundaries, I think the issue was, and Karen and I spoke about this today, is Pembroke North Condominiums. It's owned by, how many are there? However many condominium owners, that's who owns it. So instead of listing all of it, I told Karen just to say Pembroke North Condominium and refer to it as that for that site, because he's asking that all boundaries adjoining properties, the owners be named. And I think the Acme, the Acme was, we have to put, is it Lancaster Avenue, Lancaster Wayne Associates
Yeah.
LP? That is the owner?
Yeah. I think that over here this is a C2 and a C3 zoning, and it's the same owner, so we only had listed it once, but the back part of the property is the same owner.
Yeah, so we'll list, I think we'll comply because I think Roger's saying list on the back part of the property, that is Lancaster Wayne Associates LP is the owner of that also. It's a split zone. That's the old Acme that's now the strip stores, strip retail stores in there. Right, we'll comply. Number 3, this is the one on, I think it's actually the waiver one again, Karen?
Yes.
All right.
Same as the waiver.
This is the same as the waiver. Again, he's citing the section that we asked for the waiver for that I believe the board doesn't have an addition, a problem with. Number 4, again, this appears now in all of the land development applications. It's a comment that the commissioners can ask for additional right-of-way. So really, that's a noted. You know, we note that, yes, they can ask for additional right-of-way. We're not necessarily agreeing to it, but they can ask for it, and I don't think they'll, they'll ask for it in this instance because we're not really doing anything with the front. 29A2.
Already did that with the zoning commission.
With the zoning, but I think Roger may be saying it's a part of the saldo as well. I don't, I'll have to.
Roger?
Yeah, he said the applicants indicated will appear before the zoning board and ask for the
Right.
zoning relief, so we got it.
Yeah, keep in mind, a lot of these comments that are here are informational for your purpose, where it talks about the specific ordinance and how they do not meet that ordinance.
Okay.
So-
Just 6 will comply. If I say something wrong, you point it out to me, okay. 7, I know the lighting's not being changed. I think we're adding a light, okay? And I don't think it's going to impact or doesn't impact the adjoining neighbor. But, note it or we will comply with it, whatever's required there. 8, we talked about, that was the 1 tree, 2.5 caliber for every 5 parking spaces and the fee in lieu. 9, that's basically the same comment regarding the trees.
Is the street trees. So 9 is regarding street trees. So along Lancaster Avenue, we are adding 4 trees along here, and between the new ones we're adding and the existing ones, they are 30 feet or less on center. They will be. If we need to add another tree, we could possibly add 1 more in the corner if we would have to. And then Ironworks Way, we have a lot of utilities that run up here through that grassed island. So at the moment, we're only proposing 1 new tree there, and there's some existing trees in this area that doesn't quite comply with the 30 feet on center.
Have you guys come before Shade Tree, or you will, right?
We will have to.
Yes.
I don't know, I don't think we have.
I don't remember
Yeah, okay.
that, so.
So again, I would suggest if the applicant feels, if I may, Mr. Commissioner, Mr. Chairman, that if they cannot comply, that they would pay the fee in lieu of to the Shade Tree Fund.
Yes,
Okay, all right. So it's another.
acceptable. Right. Going to number 10, that's again an informational, so noted. And again, 11, we agree, so noted, that there is the park and rec fee. The stormwater, I think that's all those are will complies, Karen?
Yes.
And then the general note, if we haven't done it, we will comply with it. The last note on there, the general note. Going to Amy's letter on the traffic consultant. Again, she points out the various zoning issues that we've talked about. Then on the subdivision is basically the same comments regarding parking. And I think on number 2,
Street loading facilities?
yeah, I believe it's going to be the same way. Can we show that, Karen, on the plan?
Well, nothing changes when it comes to access on the site, as far as the driveways and the road and the way the vehicles will maneuver. Nothing changes.
And then 6.1, that's a, you know, we'll comply with that. I think she's asking for a different coloring. And that's actually been done? Okay.
There's some question regarding, with the staff, under subdivision land development, item 2. I see you talking back and forth. Was there something there?
Right. We were just talking about the truck deliveries, and I've come through Lancaster Avenue when the deliveries are being made, and it basically shuts down Lancaster Avenue when on the east-westbound approach. And I was just talking with Steve about that very issue, because I'm not here as often as he is. And that is a problem, and I'm just wondering what could be done to either make sure that those deliveries are during off-peaks or handle them on site, or make sure that they're not blocking Lancaster Avenue. It's illegal in the state of Pennsylvania to block a state road for deliveries.
I know we're trying to make accommodations to have the deliveries prepared at a different site, actually. We're working on that now. Mike knows there's, you know, a couple different sites that are being considered, that one he already has a lease on, and he's entering into a lease on another one. So we're hoping that basically to eliminate deliveries there is what we're hoping to do. Can't obviously promise that right now. I don't know, is there something we can do as to not blocking Lancaster Avenue on that? I mean, we should, yeah.
Well, can't you take deliveries at your site over where the old
Burkett
Burkett Brothers
Yeah, and that's,
lot?
yeah, that's what we're trying to, yeah.
In order to make it a little bit more township-friendly and address the issue, tomorrow I'm meeting with the head of transportation to reroute truck drivers that are making deliveries. So we're looking at the transportation and access. So currently, we cannot get underneath the railroad, the R5 line, so we'll be rerouting. So we're going on a tour and trying to see, obviously, Ace Hardware is able to accept drivers back there, and we see no reason why we couldn't gain access, you know, back. It'll be a little bit longer drive from the Port of Delaware, but it will be much more friendly. We will prohibit, there will absolutely not be allowed any access stopping on Lancaster Avenue. So we've instructed the GM on site to not accept those deliveries, to not have anyone come in. It's an unusual period of time right now. It's the end of their fiscal year, so March ends up being our busiest time of the year, and they're trying to push inventory on dealers, which is something we have to comply with in terms of being a franchisee. But we will continue to try to do everything we can to be as neighbor-friendly and customer-friendly as we can, and I would recommend that as you look at, which we really support and believe in, when you look at the trees that will be allocated, I would just really suggest it would be wonderful if we could earmark those trees for the neighbors around us as close to the site as possible. Would really be a wonderful gesture, I think, and would be well supported by the township.
We appreciate your works on the deliveries, and I think the applicant's making a lot of arrangements to do so, so that would be fine. And at the Shade Tree Commission would be the time perhaps to bring up fee in lieu of or planting at a specific spot. Just the good thing about the Shade Tree Fund is that helps fund tree planting throughout. But if you have we had a developer do this last year. They're going to plant trees on Windsor. So I think that's great. Thank you.
Just keep the staff apprised of your efforts to keep the trucks from showing up and blocking Lancaster Avenue, and what you can do to get them into some other location as you've described.
Well, the gentleman coming in tomorrow actually has recommended, you know, coming over to the township, and I hate to spring anything on the township at the last minute, but it's an opportunity for us to stress and have them understand the constraints we're under and to support, and they can deliver a message to all of their drivers that are going to contract with them to comply with what we're trying to accomplish. So I would love the opportunity while he's here in town to stop by and talk to you and make that something that we accomplish.
I think we can, I don't know if Steve has to talk to him. I think you can tell him that, we're before the planning commission and, they're recommending or demanding that no deliveries be made on Lancaster Avenue, so they're going to have to find another way to do it.
Either way, Mr. Cornelia, I'm here tomorrow, so.
Okay.
All right, Nick, anything else in here?
No, there's nothing else in the law.
Okay, so I think at this point, we'll take public comment. If there's any public comment regarding this particular application, please come up to the mic.
Hi, thank you. Darcy Richard, and I own a unit in 115 in Ironworks Way in Pembroke. North.
Speak into the microphone a little bit more.
I'm very relieved to hear about the change in plans about the delivery, and I had just a related comment. I'm hoping that it also means that the deliveries won't be rerouted into Ironworks Way, because that creates quite a safety issue, I think, for us when we're leaving or coming in from that Ironworks Way driveway. So, it's when the really long trucks are there, it's very, very hard you can't really pass them to get a good view to make your turn, and if someone is making a left, so you're aware of that. And thank you. I'm just really appreciate the rerouting. Glad to hear it.
Okay, thank you very much. Any other public comment? Any comments or discussions with the board? Can I have a motion on the preliminary final land development plan for the Jaguar Land Rover main line?
I move we approve the preliminary to final land development for Jaguar, and with any will complies and necessary improvements relative to parking and other things.
Second.
All in favor?
Aye.
Okay, let the record reflect that it was unanimously recommended for approval.
Now you're done, Mr. Cornelia.
Next on the agenda is 145 King of Prussia Road. No. I mean, look at this skinny little piece of paper we got here, okay, and all those plans.
Hi, Skip. Mike, you want to put the plans up? I'm Mark Kaplan, and I represent Brandywine Realty Trust, which is the equitable owner of the other two buildings to be built on the old Biomed site. We're here because when Penn got the entire plan approved at the preliminary stage, there was questions about who was going to own the office building, who was going to own the hotel, what shape it would be, would things be changed. I'm happy to say that our final plan, nothing is changed on the Brandywine site, and I'd like to say, okay, let me go home, and we're done. Having said that, we have Roger's review letter, and we have Amy's review letter. And with regard to Roger's review letter, well, let me say this. All of the, virtually, all, Mike? virtually all of the items that are in both review letters are items that are on the Penn site. And
Yeah, there's some, but, sorry, go ahead.
yeah, if they're not, they're very minor. So Roger's major comment is that there have been some changes to the shape of the detention basin on the Penn site, and that we need to, or Penn needs to, or Mike Kissinger, who represents both Penn and Brandywine, has to make some adjustments to the stormwater management plan. Roger's letter says that can be done at the time of the grading plan. We'll probably get it done before that, but
Is this the stormwater part of it that's on page 2?
yeah,
Where they refer to the bioretention basins?
I believe that's right. Let me, Yeah, the contours of the bioretention basins, go ahead,
I'll just grab it.
on Mike's plan have changed. The volumes have not changed, and there will be really very little difference, but the simplest thing to say is that we will give Roger those calculations between now and final. That's really just about it on Roger's letter. The other are either waivers or minor items that we'll comply with. Yes, yeah. Yeah, it's minor, there's minor changes. Oh, yes.
Might be
sure.
minor, but it still will comply,
I'm
right?
sorry, you're right. Yes, we will comply.
And finally, under general, that attracted my attention where it said that it had to have my name on there as Planning Commission Chairperson. I didn't notice that one way or the other. And number 2, tree placement, okay, that was increased, so.
And they came before Shade Tree a few weeks ago, and everything was in order.
Okay. How about with Amy's memorandum dated March 22nd, 2019?
Well, the first part of Amy's memorandum about required improvements, that's part of Penn's obligation, and it's in Penn's approval. So it's not, and it's going to be done. In fact, I was told today that bids are being let to do that work, but this, quite frankly, doesn't belong on our review. And then,
Yeah, what do you have to say about
Well,
that?
I'm providing it as a service to the Planning Commission so that you recall what the improvements were that were associated with the site. It was not in any way meant to imply that it needs to be done by this applicant. It's for the
Understood.
site as a whole.
Understood, and thank you.
okay, then we're in agreement. The other Saldo comments and the general comments, there's no change to this plan from preliminary to final. So we question why these items are being raised at this point.
I think the answer was, you just got the answer to that question, I think.
Well, having said that, Mike is going to meet with Amy and Roger and work out all of these basically minor items. So, yes, and the general comments.
1 through 4 of the Saldo comments is will comply?
No, they're going to meet and talk about them because some of them are not accurate, but they will be worked out between the engineers.
So, Mr. Chair, so aside from Mr. Kaplan's comment, they're going to have to prove to us that they are inaccurate, and if they are not inaccurate, which I don't believe they are, they're going to have to comply. Otherwise, those review comments will carry forth when it goes to the Board of Commissioners.
Steve, the problem is that a lot of these comments are not on our site, and we're not here about Penn, and we're not here about the septic.
Excuse me. No arguing back and forth with the staff. Okay, let's just stay on where you are here. I mean, what Steve just said is what Steve just said, and you're not going to change that standing here before us. So.
Well, I'm not sure that staff understood that the items are not Brandywine's responsibility.
That'll be determined at some other point in time.
That's fine. And after saying all that, they're really minor. There's nothing here of any significance at all. So.
How about under general comments?
It's the same comment.
This is, you're going to meet and talk?
Yes.
So that takes us down to, page 4 of 4. Everything on this page is some things that you're going to meet with staff about and go over and talk about. Is that right?
Correct.
I'm not sure, staff, what we're being asked to do here. There's a lot of meet and talk that's left over. Do we table this thing and wait until you're done talking and meeting?
Pardon?
I'm asking the staff, there seems like there's a few pages of meet and talk, that these things are represented to be minor. I'm not saying they're not or there are, but what else are we supposed to do with this? What are we to approve or not approve?
Well, I'm not sure of Mr. Kaplan's position, but there were plans that were submitted, and these are things that were noted on the plans. It's of no issue to me who's going to resolve them, and I don't think it should be an issue for you who's going to be resolving them. The problem is that a plan submission is before us, and there are some issues with it that don't meet ADA requirements. And I understand what you're saying, Mr. Kaplan, but that is not, I don't know if there's somebody else that can speak to these improvements and make some decision whether or not they'll be resolved.
Well, with regard to any
AD... Are you the person is your client going to be making these improvements? Yes or no?
Excuse me. Some yes, some no.
Okay.
The ones that are on our site, we're going to make those improvements. And to the extent that there are any issues with regard to ADA, Mike will meet with you, but we will resolve them. I can't sit here and talk about the stormwater detention basin on the Penn site. The resolution that was passed was that when we came back when somebody came back for final approval on this site, we had to come back and submit a final plan for this site. And our plan is clean. We have, what Mike has done is he's taken this plan and overlaid it on the other plan, on the approved plan. And with regard to our site, it's clean.
But Mr. Kaplan, with regard to the stormwater basin, your site utilizes the stormwater basin on the other side of the site. That was modified. In order for your site to gain approval, what I'm asking is that your stormwater reports meet the basin dimensions. Okay. And I've already spoken to Mr. Kissinger about this, and I don't believe that this is an issue.
No, I already said that that's a
but it's attached to this plan and this approval. Even though it's on the other side of the site, it is attached to this plan and this approval.
Roger, I said that we will comply with the stormwater comments. I said that flat out. You're right. There were changes made for whatever reason, and the stormwater has got to work for both. So we're saying we're going to comply with that. What I'm saying is that with regard to Amy's comments, there are very few that are on our site, and that's what we're here about. Having said that, I mean, we could go through them, but having said that, you and Mike meet, you'll resolve them in one way or another, but we do not, we need to move on with our approvals, and we're trying to get into the ground in July. So
I'm
none
hearing-
of these issues are planning issues.
Mr. Chairman and Mr. Kaplan, may I make a suggestion that the applicant, if they so feel, will comply with all comments applicable to this site?
That's fine, Steve.
All right, because we'll go through all these, and any comment that is applicable to this site, and some are very applicable because they're talking about hotel drop-offs, any comment applicable to this site will comply.
And furthermore, a lot of the changes on the Penn side, which Amy referred to about the ADA and items like that, are things that Penn are going to need to do as COs are applied for and things like that. So with full confidence, those comments will be addressed by one or the two parties. Again, a lot of these changes, if you notice that maybe like sidewalks on the Penn side, those are actually in relation to dealing with the fire marshal and the progression of the grading permits. So those basins on the right-hand side actually change because of construction changes or because of dealing with the fire marshal. So that aspect, Penn's not, to lack of better words, off the hook. We still need to comply with the ADA, as pointed out by Amy, and these comments will be addressed by one or the two applicants.
Okay. Anything else?
No, sir.
Good. Public comment?
Hi, Mike, can you stay up there, please? Hi, I'm Lloyd Goodman. Hi, I'm Lloyd Goodman from Radnor Racket next door. I think these are like minor typos. So a few years ago, when we converted a couple tennis courts into the rock gym, this access driveway is no longer there.
Okay.
That's just grass. Can you flip to the next page?
Sure. Lighting?
Oh boy. Is this sheet 6 and 7? Oh, no, oh, maybe go back to 6 and 7. But that was another. Okay. Oh, sorry. Just put. Yeah, there's that driveway that's not there.
Okay.
And there it is again. It is again.
It says existing access drive.
Right. It's lawn. The access drive was moved up here. Okay. Then the other one is on sheet 35.
I apologize to say I don't have 35 with me.
Oh, yikes.
Which one's that? The landscape plan?
Yeah, the landscape plan. Because, well, I can just maybe say, they're showing 3 small holly trees in the new access drive, yeah.
Okay. So we don't slide them.
Well, first of all, and then this also goes with my other comment, at the SEPTA access parking back here on the site,
He's referring to the landscape plan, which unfortunately I don't have printed out here.
I have it on, the one I looked at the Township, the hard copy was on sheet 35 of 37.
Okay. Just give us a little, some insight into what point you're driving to here.
Well, they're showing plantings on my property.
So sorry, I'll step to the mic. During the zoning phase, there was a change made. Remember the loading dock on the back side? So we actually put those there seemingly at your request. So I apologize if we were forward, but remember the loading dock was coming out at that right spot, so you made a request at one of the meetings to put those trees in. So that way it would block.
Okay, my memory's not as good as yours. I was real happy when you put the loading dock recessed behind your building. That was much appreciated, so I don't see the dumpsters, I guess. Is that the same as the loading dock?
Right, so that's why those were added to the.
Okay.
Those were added
So-
to the plan honestly for your benefit, but
Yeah,
you don't.
no, okay, okay, I would accept those, but, you know, you don't want to show them in the driveway.
No,
See,
that's
right.
clearly
Okay, but back here, these 5 willow oaks, they're not going to, yeah, they're on my property, but I don't think they're going to work. I have already big trees here. It's just going to be jammed, and they're going to compete for everything. So can you, I don't want those, thank you.
We'll fix it.
Okay. So, but, and then these, yeah, so, yeah, whatever those little, they were American hollies. 3 shrubs, I think.
They're about 10 to
10,
12.
10 to 12 foot, okay. So I guess you work with me on placing them, whatever?
Absolutely.
So with that, I guess a typical landscape contractor gives a 1-year care and warranty, and then after that, I take care of them.
Right, so
Yeah.
we will be required to escrow those. So
Oh,
that'll be
okay.
within the township maintenance program.
Okay. Maintenance program.
All right,
for
you
how
know,
long?
I'm not sure this fits into public
Oh,
comment.
okay.
This is more like public negotiation.
Okay,
So
well, it's
I think you can go work it out someplace.
Okay, all right, thank you.
All right. Thank you. Any other public comment? Any board comments?
Yeah, I just have one comment. I say, when to deal with Amy's memo, and you're basically saying this is not our problem, this is Penn Medicine's. I would just ask is like basically, when you meet with staff, if you could have both sets of engineers representing.
We're the same engineer.
Oh, you're same engineer?
Yeah,
Okay.
so when
Okay.
Mike said it's going to get taken care of, he can really speak, he can
Okay.
speak for Penn.
Okay.
I'll make the motion.
You gonna make the motion?
I'm going to make the motion.
You gonna do it?
I'll make a motion.
Mike, can you mic that, please?
Sorry. I think what we're looking for is a motion that will say, well, we'll comply with all comments applicable to this site by the applicant, and give us the name of the applicant, which is BDR Radnor Hospitality Group, right? Is that correct?
I think we have, there's two applicants. I think the name's on both.
Well, I have as BDR Radnor Hospitality Property 1 LP as the applicant.
One of them is Brandywine.
Oh, yeah, the application, Mr. Chairman, the application got both names on it. In very, very small type, but it's got both names on it. Oh, it's right up front, right on the front sheet of the plans.
BDN Radnor Hospitality Property 1 LP and BDN Radnor Property 1 LP?
Yes. Right.
Here they are.
Okay. I make a motion that we approved the final land development plan as submitted by BDN Radnor Hospitality Property and BDN Radnor Property 1, with noting that request for approval of the waivers, and noting that the letters submitted by Amy Kaminsky, that the items listed in there be addressed with the engineer of record to her satisfaction. That's it.
Second, anybody?
I'll second.
All in favor?
Aye.
Okay, it looks like
Thank
it's
you.
been passed unanimously.
Thank you.
Just for the record, it was passed unanimously by the board. Thank you.
Thank you.
So next on the agenda is a proposed PLO parking amendment. Well, it says on the agenda PLO, but I'll read what the ordinance says. An ordinance of Radnor Township, Delaware County, Pennsylvania, amending Chapter 280 of the Code of the Township of Radnor, Section 280-103, off-street parking, to provide for minimum standards for off-street parking for general, professional, and medical uses.
I have a quick question for Mary. Mary, this is township-wide, this ordinance. Did you prepare it?
I did not prepare it, and I apologize that I don't know that much about it. It just came out of the Board of Commissioners at its last meeting,
Well,
and
our recommendation was that it would be township-wide. If it is not township-wide, I wouldn't recommend it.
So, Mr. Kunda, the solicitor is correct. This came from the Board of Commissioners, so what we're here for tonight, if it so pleases this board, is to make sure we have all your comments as a group, so Trish can get them, and then we'll shoot something back to you, and actually we'd love to have a memo come from the Planning Commission to the Board of Commissioners with your comments.
Well, that's one of my pet things. It's township-wide.
Well, I guess that's the first thing. You're right. It should be township-wide. I can't tell from reading this. I assume it is, although I don't have Chapter 280-103 memorized.
If I could clarify, it may have been confusing because we had previously discussed the parking while we were working through the PLO information. And so that's where it originally initiated, and then it came back through the board. So that's why it may just be identified as PLO parking amendment.
Well, there was a memo from John Rice, I guess, in 2017, that we incorporated in our recommendation to the BOC. And in case there's any ambiguity, certainly the comment I want, and I think everybody here wants, is that it's township-wide. I mean,
I'm looking at it now, and 103, it looks to me as if it would as well. It's under 103 off-street parking, where you list every use and exactly how many parking spaces are required. There's no indication in the ordinance or in the existing 103 that would limit it to a specific zoning district.
But am I correct that it's amending an existing ordinance with just off-street parking regarding medical/dental offices, including ambulatory care? And
well-
then Section 2 is just these office buildings that they've type of office buildings of various sizes that they've identified?
I'm looking at the zoning ordinance, and subsection 8 is reserved. And it appears that the medical dental offices will be new and placed under a reserve portion. Item number 11 is already there, and it is an amendment to the existing 11, which provides parking spaces for office buildings or banks. And it's amended to include, right now the ordinance just says office buildings or banks. Now it will say office buildings, including general, professional, and sales or banks. Right now it says one space for every 200 square feet of floor area for the first 50,000 square feet, plus one space for every 300 square feet over 50,000 square feet, so no change there. Drive-in banking facilities shall provide 12 spaces for stacking. So the only thing that's really being changed there is the addition of the language saying including general, professional, and sales offices. So to answer your question, it is a general application on a township-wide basis, and those are the changes.
so I like it.
Hey, did Kathy want to talk about this at some length?
Well, we did. We did. I think her last meeting, we sent it off as a recommendation. And they acted on it.
So Mary, what they really did is they inserted 11 where it was reserved, and now it actually has something in it.
No, 8 was
Well,
reserved.
that's what I meant, 8. I said
Yes,
11, but
I'm
I meant
sorry.
8. 8 was reserved, and this is now 8.
That is
So it's no
correct.
longer going to have it. And these are, John, these are under general. So this is for all parking, okay? but
So it's township-wide?
individual- Pardon me?
It's township-wide?
Yeah, because what they're doing is they're defining, it appears to me, and you correct me if I'm wrong, Mary, it appears to me that what they're doing is defining individual classifications within the whole ordinance. Because it's in general, so it means that it includes all of it. And each one of these things pertains to a specific use within the township. Like, for instance, 4 is hotels and motels, 2 is dormitories, 1 is dwellings, 12 is wholesale establishments. Now 8's going to be medical office buildings, right? And they changed 11 and added whatever they added in there, whatever they added.
Sales.
Okay, sales. So they've kind of now defined a new category, which wasn't, I guess, in the ordinance before, which is that the medical buildings, dental offices in 8, which didn't have a specific.
Most zoning ordinances
Right.
do distinguish between medical offices and other office buildings because of the parking demands
Right.
placed on medical offices.
So it is township-wide.
I do have one comment on number 11, where it says office buildings, including general, professional, and sales, or banks. It seems like not particularly facile way of expressing it. It includes banks, correct?
The existing ordinance includes banks, so maybe the
Shouldn't it read
wording's a little
professional?
awkward, but it was simply inserting a
Why don't
phrase
it
to
be-
modify or explain
It should be
which
stated
office.
in
Shouldn't
the-
say and banks.
It should be in the conjunctive, not the disjunctive. I think it should be
I think it should-
professional, comma, sales, and banks.
Why wouldn't you just say office buildings and basically say that, use the word commercial office buildings, which includes general office for any classification of a business? And then with banks, are you talking about a retail bank, or are you talking about a bank function in a large multi-tenanted office building?
I would never start out by saying commercial offices, because that gives the developer a chance to say, my office building really isn't commercial, it's something else. I would leave it just with the word office. As far as banks go, most of the time, we distinguish when we're interpreting these between financial establishment, for offices for financial establishment, and banks. Bank meaning available to the consumer, and the other obviously being an office building.
So what happens if you have a tech startup? Where does that fall into this definition?
Well, your ordinance doesn't go that deep into offices. Some ordinances, a tech startup would be an office.
Okay.
And another thing that I think we have to kind of be aware of is in banks today, and I don't know if it was in front of here or was in front of zoning, where banks are becoming more drive-through banks than they are actually having clientele that go into the banks and make their deposits. And I think it's even going to get less drop-off and go inside, because the banks are even charging you, at some point, going to start charging you for deposits. So people aren't going to do it. They're all going to do everything online. Just like with, I think the problem we're going to have with as Matt had talked about earlier, with Wawa is, our ordinance is all designed for how gas stations were 50 years ago and 60 years ago. That's not the way service stations are today. So I think everything's going to we've got to kind of upgrade ourselves so that we're ahead of the curve as opposed to behind the curve, because they're going to wind up in court and the judges are going to give these people whatever they want, because that's the way things are today. So that's what we got to have to do.
I want to go back to my other comment about or banks. Is there a reason for why it's stated like that, Mary? including general, professional, and sales, comma, or banks.
So you'd like that to be the conjunction,
Yes.
right? Make them move that.
Also, you're tying in the parking restriction to floor area. Why wouldn't it be maybe net leasable area? Because in that way, you're really tying out, the standard typically for a real estate developer is for every 200 square feet, or it used to be, let me take a step back. Before the standard suburban office building, it was always, you would always want to design maybe about 200 square feet for every individual worker. And now the parking ratio has always been sort of like a 4-to-1, so if it's basically it's like 250 square feet used to be for every single worker. So right now, why wouldn't you tie in the requirement to a net leasable calculation? So, because that's really how many bodies are going to be sitting in an office building. So if you have an office suite, multi-tenanted office building, 10,000 square feet net, that's 10,000 typically divided by 150 people. Those are how many cars are going to be parked in your parking lot. So I would just say, I would just make the language tighter using a net leasable calculation rather than with what you're talking about right now, floor area. It's just gross.
Here's the problem with that, is that if you do it by net rentable area, okay, this way they're going to have less cars overall, because what they're going to start doing is using hallways and everything. So you kind of want to make it so that they have more parking needed, and that's kind of what you want to do. Right? And if you start doing it by net and say, well, we only have 100 square feet, well, we only need one car, well, you really have 200, so you really need 2 car parking spaces.
Mr.
You know what I
Nat,
mean?
you could also have to look at, so when these plans come before this commission, they're a big square or a rectangle on a plan,
Yeah.
gross square foot area. So the applicant doesn't necessarily know what the fit out will be. So it's usually at that stage not designed to that level. So you want to go by the gross square foot area, because when they do their tenant fit out, all that could change. This way, gross square foot area covers whatever the applicant's architect will do once they design that site. Oftentimes, these buildings are only partially leased or not leased at all when they come before you.
My comment is like, what would I want? As a planner, would I want basically a huge parking field, surface parking field, or would I want something smaller?
I understand what you're saying. The trend in planning is to try and go with less impervious as opposed to more impervious. And when you're looking at, the traditional bank building, most ordinances, especially ordinances old as yours, overpark them. However, when you're looking at office buildings, in the older office buildings, I see more of them coming into townships with requests to expand their parking area because they're putting more and more units into the building than any time before. And they're almost always underparked, and it's necessary to expand the parking field to be able to lease them out. So banks might be going in one direction, office buildings are going in another.
Mm-hmm. Okay.
Can you, what is the size of the parking space? What is the requirement?
9.5 by 20? Yeah, it's 9.5 or 10 by 20.
It's 10 by 20?
I think it's 9.5.
9.5.
Yeah. I don't have my.
9.5 by 20. And is there an aisle width requirement?
22 feet.
Okay.
You need 62 feet to have that parking. But to Mr. Nat's comment, on number 8, I sort of agree with you in that for medical and dental, my recommendation is it should be based on the actual examining rooms. Because to me, a blank square, a blank palette of medical or dental offices, a lot changes with hallway widths, storage rooms, and so forth. The driver in medical and dental is, how many chairs, how many dental chairs, how many dental examining rooms you have. That was just one comment. Well, my other one kind of goes with Mr. Falcone. Stacking for 12 automobiles in a drive-in bank, I think, is an outdated number. If you remember, we had two financial institutions come in here not too long ago, and both of them made very clear that their brick and mortar building was more for presence, not so much for actual people driving through. And that's why so I would just consider perhaps reducing that. That is something, having the ability to stack 12 cars is something that could really drive a site. And I don't know that many cars is necessary in today's age.
Steve, as to medical dental, that statistic is research that Kathy and I were doing last year, that, it's also people in waiting rooms.
Good point, sir.
One of the things, if you're going to go in the direction that Steve's suggesting, is that usually those ordinances read X number of spaces per examination room, somewhere between 2 and 3, so that you're not just taking into consideration the person that's in the examination room, but the person waiting to go in.
I think
plus one for each employee.
But I mean, it's 6 and a fraction now on 1,000, and it's an improvement from where we are.
It's just a suggestion, sir.
Yeah. Well, this is actually what we requested, and our outside consultant, Steve, from Retu, said the same thing, said 1 per 150, back in his presentation to us some time ago. I don't want to weaken it at all.
So then I guess my request would be, if we go through this, maybe we don't need a memo, we'll just revise this. We'll get an open document, we'll revise it to the exact wording this Planning Commission wants, and we'll submit that back to the Board of Commissioners. If you wouldn't mind, if we step through that one more time, I'm sorry we've gone all over the place, but if we could just step through, whether it's the and or, and any other changes, we'll make those comments, we'll have a strike through, and the board can see exactly what you folks wanted again.
I want you to repeat your comment regarding stacking. Did you think that 12 cars were too many or too?
I do, sir. I think that's an outdated stacking. I don't think any drive-through is going to have 12 cars. 30 years ago, absolutely. I believe it was either Arden or First Resource who said the only reason they're there is to have a presence with a brick and mortar store.
Do you have a recommendation for a new number or a different number other than 12? I mean, 10, 8?
I could let our traffic engineer research a proper number. Offhand, I'm thinking 5, but I'd rather go with facts from our traffic engineer. I definitely think that's on the magnitude of twice too many, at least.
The only thing that we have a problem in Radnor, it seems, all these stacking things wind up stacking on Lancaster Avenue. So I don't know if there's some way we can differentiate between Lancaster Avenue and everywhere else. Because that's always seems to be they want to stack cars, and all of a sudden it's 5 cars and 3 of them are on Lancaster Avenue.
And that's where all our banks are coming in. I mean, over the last 10 years, if you drive from Sugartown east, look left, look right, there's a bank.
I'm looking at an ordinance that Amy's firm did about 8 months ago, and they went with 4 queue spaces per teller of drive-in space. That's still,
That'd be per lane.
that still
low.
seems a lot. You think it's low?
I think it's low. 4 on a Friday.
4 spaces
Just to
per teller?
respond to
How do
what
you know
were
how many
saying.
tellers are in the building?
Yes.
A drive-through
So it would
tellers,
be,
I'm
yeah.
sorry.
It would
like-
be a drive-through lane.
Commerce Bank, which has the 2 lanes, and there's 2 tellers with the pneumatic things, so they need stacking for 8. I think the solicitors come up with a good idea, base it per teller.
Talking about drive-ins, okay?
You mean like,
I think once you start getting beyond that people tend not to go in then, because they don't want to sit and wait through 4 transactions before they get up there.
you have to have 4 spaces
And-
for 1 lighted doorway.
Right.
And if there's 2 lighted doorways, so to speak, then you'd have
Maybe
to have
8.
4 and
Correct.
4.
Correct.
It's really only 3. It'd be one in the actual space and then 3 behind it, right? So it's
They count as 4.
Okay.
So we,
So what I'm saying is
we
there's-
make our measurement from the beginning of where you are actually being serviced, and then we start counting from that point backwards. And then we typically do 25 feet per vehicle so that we have an understanding of the distance. And then just in response to the queue backing up onto Lancaster Avenue, if you recall, we did have, I believe it was Ardent Credit Union came in, and we had them churned, we had made them alter their site, so the queue occurred all the way around the building and kept it off Lancaster. So we're aware of it and trying to resolve that.
Would this consider reducing the size of the parking space? I mean, 9.5 by 20 is quite large. I mean, most now are 9 by 18. I mean, that's 28 extra square feet.
I have quite a few municipalities that still hold the 10 by 20. I prefer for short-term parking, meaning if you're at a Wawa or something, to go with a wider, because people are in a hurry. They're, jumping in and out of parking spaces frequently. So I don't think I would go less than 9.5 feet personally.
Not only that, they're stop making little cars. Everybody's buying trucks and SUVs.
You go to the parking.
No, but it adds quite a lot of impervious surface too.
But if you go to the structured parking at Bryn Mawr Hospital and you park in there, open your door and see how easy it is to get out of your car. So that's what happens when you start getting down to the 8.5-foot width level.
And just to echo what Amy said, most municipalities are okay with the narrower parking spaces for an office use where somebody's going to drive in, park their car, stay all day, and come out at night. But at the grocery store, that's not as convenient.
Well, having more parking is okay, I suppose, but having less impervious surface would be really good also, probably even more so.
Well, here's one
I
of
would
the
think if you want
problems.
to increase the parking spaces, you would reduce the size of the parking.
Well, they can apply for a variance, or if they need to have that type of situation, they can apply to have a waiver for that.
It's really not before us in this, really, in this proposed ordinance. It's,
One of the side effects of more parking for, let's say, medical dental, is that basically it keeps the facility slightly smaller because you have to have slightly more parking, and which means your traffic is probably reduced because they're not forcing too many cars and a medical facility on the same site. If you go to the dentist and you have to park in the next door neighbor's commercial lot, that's one of the other problems of not having enough parking.
I think we should change, Steve had mentioned that, make it four stacking cars per drive-through lane. I think that's a good solution.
So that would read, banking facility shall provide for the stacking of 4 automobiles per lane,
Per drive-through lane.
per drive-through lane.
Right.
And the other change was professional and sales, comma, and banks.
including general, comma, professional, comma, sales, and banks. And it's got a semicolon, which I think.
I think what it should be, I think
I am
the better.
a firm believer in the Oxford comma because, and I'm looking at this now, and so office buildings, and it should be including general, I thought it was professional and sales, so it's general comma, professional comma, sales comma, and banks?
No,
Yes.
I think what it should be, Mary, it should be office buildings, comma, including general, comma, professional, comma, and sales, semicolon, or banks, because that's a different category.
Well, I thought we were going to go with and banks.
Or and banks, either one, but I think you need to put
I think the
a
semicolon.
semicolon after that to
Right.
break it from, because you're talking about office buildings in the general, professional, and sales, and then banks a new category. So you got to differentiate it other than a comma.
I like that. Eat, shoots, and leaves, right?
So could I just go, I'm sorry, for Tricia's sake, could I go through that just one more time? Because she's going to have to, we're going to have to get.
The office, all right, on that one, I believe it's supposed to read on 11, office buildings, comma, including general, comma, professional, comma, and sales, semicolon, and banks.
And then that should be colon after banks.
Right, that should be colon, yes.
You know, I think I'm something of a wordsmith based on what I do for a living. I've never seen a semicolon in a position like that. I mean, really, if you're drafters of ordinances, I'm not. If that's a common way of
Well,
doing things,
and I-
go ahead and do it, but
The point you're making is a semicolon is usually for two independent clauses, and the second one is a dependent clause. I do think that the suggestion adds clarity to the provision, and with ordinances, I'll take clarity over grammar any time.
my objection was I don't think it's clear with a semicolon parked in there, but that's, I'll defer.
John, we could put banks up front. Could we put banks and office, and then you could put your comma, and then you could put your colon, and not have any semicolon?
You know, it's 9:05, we should be discussing colons, or semicolons.
I like that.
Good?
Are they hearing you? Do they know you're making a change?
I don't care. We're good.
So we have your comments. If the commission wishes to vote on those comments, we will provide that to the Board of Commissioners as well as a copy to the Planning Commission.
So there's nothing else for us to do? We're complete with that now?
Yes, sir.
Okay.
You were putting the 4. So if it's okay with this, if it so pleases this commission, I would have this back in front of the Board of Commissioners next Monday.
Do you need a vote on that? I think we're all agreed.
If you could vote, please.
Okay. Can I have a motion, please?
I move we submit to the commissioners our revisions to the revised parking ordinances.
Second.
All in favor?
Opposed? I want smaller parking spaces. But on this issue, yes, I'll add mine.
Okay, so it's been approved, the edits that we have recommended to the proposed ordinance. So the next thing on the agenda, there's no public comment, obviously. Public comment, no. Old business. New business. I think we're adjourned.
I move we adjourn.
So moved.